Okay, we are live. I am attorney Vince Davis, and this is The Secret, How to Fight CPS and Win. I'm joined tonight by my very special guest. Is it Kirsten? Am I pronouncing that right?
Yes, that's correct.
Kirsten, how are you?
I'm doing okay. How are you?
Good. Where do you live, or where was your case?
So it's a little confusing. I live in Ventura County. My case first began in 2020 in LA County, and now it has been transferred to Ventura County because it's still open.
Did you move to Ventura?
No, I've actually lived out in Ventura County my whole life.
Oh, okay.
Yeah.
How'd your case get started in LA County?
So the situation that led to the dependency of my children started in LA County. It happened when I went into labor with my third child, and I was out in Lancaster area of all places. So I ended up having her out there, and that's how LA County first got involved.
Okay. So how long have you been involved with CPS?
As of yesterday, it's been 3 years.
3 years. Are your
Mhm.
kids with you or not with you?
They are not with me. But I actually still have reunification services and I'm still fighting for them.
That's amazing. You have reunification services after 3 years.
Still, yes,
Mm.
the judge gave me more reunification services and said that this was a very exceptional circumstance for me, and the department's not very happy about it.
No, because I don't think they get reimbursed after 18 months or 24 months maybe.
I think maybe 24.
Yeah.
Yeah, they were giving me a really hard time. They're actually kind of going against the court orders. My caseworker admitted it to me that she's been directed by the department to go against the court orders for more reunification. So they've been treating me like I've had no reunification.
You know, I don't know who your attorney is, but you should tell your attorney that. And there is a motion that you might be able to make to have your case, to have DCFS taken off your case.
Really?
There are provisions actually in the Welfare and Institutions Code, I believe, that if the county can't service you,
Mm-hmm.
the state has to do it. And I think in one or two of my cases in my career, the state actually intervened and took over the case.
Okay. I'm going to
They
write that
actually
down.
they actually have social workers at the state level that this is their job
Mm-hmm.
or part of their job to intervene in county cases where the county can't appropriately service the case for whatever reason.
Mm-hmm.
Typically, you find that in these smaller counties in California where, mom might be related to someone at CPS, that type of thing. And,
Okay.
there's some type of inherent conflict. But if a worker tells you that she's been ordered not to give you services against court orders, not only should they be removed from the case, but your attorney and you should probably bring some type of motions for sanctions or contempt. Because,
Okay.
because when you first mentioned this to me, I said, they're probably not getting paid. And listen, they're in the business of doing all of this to get paid. And you're
Absolutely.
and you're right. You can get up to 24 months of FR services. But after that, you're not supposed to be able to get them because the county's is not being paid for them.
Exactly.
I mean, I think the federal government believes that who's paying for everything believes if they can't reunite you within 24 months, 18 months really, there's something wrong. Now that means
Mm-hmm.
you're something wrong with you or something wrong with the CPS. And if you don't have your children back after 24 months, something's wrong. And the judge is still giving you FR services, which is amazing. I don't think I've ever gotten FR services past 24 months.
Really?
Yeah.
Wow. Yeah, I did. I don't think that the clock stopped. So I reunified with my children in November of 2021. I then had them with me until they were there was a 342 petition based on it was actually the caseworker that called in to the hotline for both counties, both LA County and Ventura County at the time, which I can explain. But they took my children away again. One of them was without a warrant, and they instantly tried to terminate my reunification services. They, I guess, even filed, I think maybe it's a 388 on their part, but they did a walk-on requesting to terminate, and the judge denied it. That was even before the jurisdiction disposition hearing. And once we finally got to court, I went to bat with just my court-appointed attorney, and she worked really hard. And the judge and the guardian ad litem and county council all congratulated me and told me, "Good job, mom. And it's clear to all of us that you are going to get your kids back and that you're their mom, nobody else." So,
How old are your kids?
so I have 5 kids in total. I have a 7-year-old son who's not part of the case. The department gave him to his dad. And then I have 3 daughters, a 3-year-old, a 2-year-old, a 1-year-old. And then I actually just recently had a baby last month. And so he's about 3 weeks old almost.
Wait, you had a baby last month?
Yeah, which the department also took.
Well, did you have a detention hearing?
Yes, I did have a detention hearing, and of course, the judge, made all of the findings, and they're basing it on my just the fact that I have an open dependency case with my other children, and that they're not back in my custody, so they took him as well.
That's not the law.
That's what I thought. I wasn't sure, but
They can't
okay.
do it just on the fact that you'd have an open dependency case. They also have to show some risk. Now, here's the interesting thing. If you're getting all this FR services over 24 months, that means you must have done something.
I've been working my butt off. My daughters were placed 2.5 hours away, actually. So not only am I
In what
driving
county?
in LA County, they're in, do you know where Lake Los Angeles is?
Isn't it in the Antelope Valley as well?
Correct. So it's past Lancaster, but it's about 2.5 hours away from where I live, which is in Camarillo in Ventura County. They are with their dad's family members. So
Do you get along with them?
they don't like me at all, unfortunately. I do my best, but they do not like me.
Is
So
dad involved in the case?
no.
You didn't have any relatives?
I did, and the department, I mean, they were actually present during the second removal, asking for placement, and the department flat out denied them, wouldn't even consider them just because they already made up their minds that they were going to place with this person. And I know that I'm pretty sure that's also against the law too, that they are supposed to consider any and all family members, especially ones that request, right?
Well, it depends, yeah. But here's the thing. The person that they're with now,
Mm-hmm.
what level of relationship are they? Are they grandparents, aunt, uncle?
Aunt. It's their paternal aunt.
Okay. So just to let you know, that's a first level placement.
Mm-hmm.
But what I see happen a lot of times is they go out and find the relative that hates you to make sure there's no reunification services.
Yeah,
Everything is
yeah.
so subtle in the strategies of CPS. And it's difficult sometimes because I get the feeling judges do not believe that CPS workers are this biased. And the strategies they come up with are so subtle. It seems like every little thing that they can do to make sure that you don't reunify, they take advantage of. It's almost like playing tournament poker with
Mhm.
someone. In playing poker, people try to get every little advantage they can in the game.
Oh, yeah.
And that's what DC or CPS does. And the reason why they do it, because over the long run, those little advantages start to add up and they're stacked against you. And all of a sudden, you're just going straight uphill. And it shouldn't be
Yeah.
that difficult. The second time the kids were taken from you, did you have an adjudication and disposition hearing?
I did, and it was very confusing because they had both LA County and Ventura County involved. So LA County took my two older daughters, so my now 3 and 2-year-old, but they could not touch my 1-year-old daughter because I had had her during the course of my case being open in Ventura County. So we only lived in Ventura County. So came to find out through the Title 20s that they had contacted Ventura County because Ventura County threw the referral out and they evaluated it out. They didn't want to take it. But they contacted them, made them reopen the referral, and also told them, hey, we're going and we're taking, the two older siblings. So you guys have to take the baby. And you can't leave the baby with mom if we're taking the other ones. So they all came out um, and took the baby without a warrant. And it was a mess. So I had two counties that I was fighting for my kids when they were in the same placement. Um, but yeah, I had all of the hearings, and it was very interesting. I was told by court appointed counsel to just plead guilty basically in Ventura County and to just deal with it. But then my court appointed attorney in LA County said, nope, this is wrong. And I've known you since the beginning in 2020, and this was a wrongful removal. And I'm going to do what I can to get you, more time at the very least, because they were obviously trying to terminate.
Well, let me ask you this.
Hmm.
The second time, did you have a trial regarding the adjudication or jurisdictional hearing and the disposition hearing?
So
Hold on,
when you,
hold on, hold on. Now this is an important point I want to make.
okay.
So tell me yes, no, or I'm not sure.
Well, when you say trial, would that be the jurisdiction hearing?
Well, there could be a jurisdictional hearing
Uh-huh.
that's a trial or not a trial.
Oh,
So what I'm asking you is, did you have, and it's also known as a contested hearing. Did you have a
okay.
contested jurisdictional hearing and a contested dispositional hearing?
I had a contested jurisdictional hearing in Los Angeles County. I did not have a contested dispositional hearing in Los Angeles County, and I did not get either in Ventura County.
Okay. Now I want to explain something to you because this is an important distinction for you and the viewers. The jurisdictional hearing is only to determine by a preponderance of evidence that the allegations that they are alleged are true and that they put the child at risk or, you know, for some type of abuse. That's the jurisdictional hearing. Now, what people don't realize is that you could lose the jurisdictional hearing and win the dispositional hearing and get the kids back.
Mm,
But what I see a lot of times, and I think it's maybe based upon a little misunderstanding, or maybe that's the way people are thinking these days, that if you lose the jurisdictional hearing, you're just going to lose the disposition hearing by default. And that's not true. The reason why it's not true is because the dispositional hearing is a different law, a different burden of proof.
that's
So,
right.
so dispositional hearings have to prove by clear and convincing evidence which is way above preponderance. And they have to prove not a risk, they have to prove that you are a substantial danger, not just a danger, a substantial danger. Plus, and here's the part everybody forgets about, they have to prove by clear and convincing evidence there are no less restrictive alternatives.
Mhm.
Okay. Now, I would bet you $1 that if you got 100 parents together that had contested dispositional hearings, that the issue of no less restrictive alternatives at a clear and convincing level ever came up in the hearing. It's like part of the case that people just forget about or assume that if you lose the first one, you must lose the second one. Not true. So here's what some people do. They call as a witness the person most knowledgeable about family maintenance services in the county. In other words, there are all these services that they could give you to eliminate or prevent the removal of the child, even if you're a danger.
Mhm.
Let me give you an example. Let's say you're, and I don't know anything about your case. So I'm not saying this is you. I'm just, as an example.
Okay.
Let's say that your child was taken away for two reasons: domestic violence and drug abuse.
Mhm.
Those seem to be the big two these days. Here's a less restrictive alternative. Kirsten, you get to keep the child as long as you test clean. And you get to keep the child if your mother moves in with you to make sure that you're no longer around the guy or gal that you were having domestic violence with.
Yeah.
Those are less restrictive alternatives. 20 years ago, social workers or agencies, CPS social workers, if you had a drug case, would not take your child away from you. Instead, they would have you test and they would see the child every day at school to make sure the child was being taken care of.
Mhm.
Because let's face it, there are many, 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 many functional addicts in the world. That doesn't mean they should lose their child. You know, CPS laws were never meant to be strict liability. In other words, use drugs, lose your child. That's not how the law reads, even in the cases today. But when you go into court, I mean, that's the feeling I get. Oh, she tested positive. Well, even if it were true, she tested positive 1 out of 50 times. Does that mean she can't take care of her child? Does that mean there's no less restrictive alternatives? No, I don't think so. So every once in a while, you get a not a court, you get a court of appeals case
Mhm.
that explains to us, hey, before you take care of a child, these are very high standards. So mom got involved with a domestic violence and was using drugs. So what? Has she remedied that? Are there safeguards? So if there are safeguards, then we shouldn't be taking kids away. I did a case, it's been several years, maybe 5, 6 years ago. I did a
Mhm.
case up in Northern California and I subpoenaed the person most knowledgeable
Nice.
from, from CPS. Now, here's the funny thing. The attorney for the social worker didn't even realize what I was doing. She never talked to and prepared this witness. And I put the witness on the stand and I said, hey, you're the person most knowledgeable in family maintenance services? Yeah, that's me. I said, well, what does that mean? And she testified something like, well, It's my job to keep children at home so we don't have to take them away. And right then and there, I knew nobody clued this lady in as to what they were trying to do, which was keep the kid away from my client.
Oh boy.
So I said, "Well, what kind of services do you offer for that?" "Oh, there's many, many services." And at that point, the judge goes, "Like, many, many services? Like, what services? I've never heard of this." And and
Oh
and here's
man.
the interesting thing. He was a judge that was not new to dependency. He just didn't know because nobody ever
Oh
brought it
wow.
up.
Oh
Nobody brought
wow.
it up. So she starts telling about all these different services. And, she finishes testifying and she gets off the stand and the judge comments, "I've never heard of half of those services."
Oh wow.
You know, and I guess some of the services, I guess perhaps they had heard of, but they were like urban myths.
Mhm.
Like, I heard of that, but it doesn't really exist.
Oh wow.
So you right now, I can tell, I bet you a dollar you don't know all the family maintenance services they can provide you to keep your children together at home.
Oh no, not at all. I do know that they get a lot less funding for it though.
Well, no, they get funding. They get a lot of funding. They just don't spend the money. See,
Exactly.
the trick is, they're a business, right? They make money. How do you make money? You increase revenues and you increase revenues by detaining children,
Mhm.
and you decrease expenses. What expenses do you have? Well, those family reunification services we're supposed to be giving the parents. We're going to bring that way down. If you think about it, think about this just in your case. What is the incentive for them not to give you family reunification services? What is the incentive of them trying to keep your kids away from you? Well, number one, you could say, well, social worker has an agenda against me.
Well, yeah, but I'm sure they'll make a lot more money adopting my children out as opposed to the
Money,
yeah,
baby. It's the
yeah,
money.
always.
And I several years ago I did a case in a county. I won't say the county, but um one of the attorneys who was of the same ilk as me argued to the judge that, these financial incentives. And in making the ruling against us, the judge said, oh, that the judge didn't believe that there were financial incentives that were affecting the department's recommendations.
What?
Yeah. And this judge wasn't a new judge, by the way, in juvenile dependency.
Oh, wow. They should know. I mean, they should absolutely know.
Why? Why? How do they know? All they're doing is protecting children. That's all they're doing. That's all they're doing.
Yes, but it goes deeper than that because, like in my case, they're traumatizing my children. Like they're harming my children more than I ever could have, even if I tried.
Do you
But
do you actually think they care? Do you think that?
no, no, I mean, I think that there are some workers that do care, but I think that they're just one person or a couple people in the department can't do anything. And as soon as someone, I mean, I've actually met some social workers who told me, I mean, they were monitors. One of them had actually stepped down as a caseworker because of she was involved in a case in Antelope Valley where the child reunified with his parents and he died. Um, there's going to be a huge thing about it. That was one of the more recent deaths of a child in Antelope Valley that DCFS was involved with. But she was a monitor for my visitation, and she saw me crying, cleaning up everything that I had brought for my daughters after they had left with the caregiver. And she said that the department basically there are cases that she's seen where mom or dad should absolutely have the kids back or mom or dad should absolutely not have the kids back, but it doesn't really matter. It just matters, like the department makes up its mind. Basically someone within the department makes up their mind no matter what the parent does or doesn't do, and that's, I guess, just what they go by. And she said that they had already made up their mind about my case, and that's absolutely terrifying to me. Like, I don't know what to do, and it's gotten worse over time, just with the little things like what you mentioned, and how they're just stacking it all up against me. I mean, even just placing my daughter's 2.5 hours away. I drive 5 hours, if not more, with traffic to see my daughters for 1 hour, for example. I've been drug testing, for years, 2 hours away, one way, once a week at random. They didn't offer me any services. I went and found them on my own, and they're still trying to complain about the services that I'm doing, but yet at most they've handed me a packet of, most of the services are already long gone anyway because the packet's from 2018, and they just they they don't care at all. So
When is
it's
your next court hearing?
I have one coming up on March 23rd. So
So this
it's a
is the 20.
contested.
Oh, it's contested 24-month date.
It is. It's a hearing for my youngest son. I just had the detention hearing for him, and I contested it, so they continued it for 30 days. So,
So here's the thing. You should talk to your lawyer about having a contested juris and disposition hearing.
okay.
I can remember one of the easiest ways that I used to do this is 20 years ago, 25 years ago, as a court appointed attorney, is to give the department language that they
Mhm.
want and plead out on the juris and then contest the dispo, because that makes the judge focus on what the disposition statute really says. Judge doesn't
Mm.
get involved in, well, did the DV really happen? Did
Mhm.
the drug abuse really happen? You know,
Okay.
you know, we don't want you focusing on that, judge, because if we try to
Mm.
prove that wrong, you're going to get pissed off at me because you believe the social worker and not me.
Yeah.
And
Okay.
then you're not going to be focused on what the law is in the dispositional hearing.
Oh, you're going to be focusing on everything that you just heard during the hearing, right?
Right. And then when it comes time to do dispo, see, an odd thing happened maybe 15, 20 years ago, maybe longer, maybe 25 years ago. An odd thing happened. Jurisdictional hearings and dispositional hearings were done separately. Always,
Mhm.
always done separately, because they're really two different things,
They are. Yeah.
two different burdens of proof, two different legal tests. They're different.
Yeah.
And then what happened? Somebody got the bright idea to save money
Of
and
course.
judicial time to combine the two hearings together. Okay.
Okay.
And the Supreme Court and the appellates court said, oh, yeah, that's okay. Judges are smart enough to know how to keep it separated in their minds. You know, they're just human beings, right?
Mhm.
And all of a sudden, they combine jurisdictional and dispositional hearings. No, I don't know if you've ever done any studies about, the persuasion of people, like a trial course, like a Jerry Spence Trial Lawyers College kind of thing, or Trial Lawyers University with Dan Ambrose. But convincing somebody is a very subtle and kind of scientific thing.
Mhm.
And if you combine those, it's a disadvantage to the parent, automatic disadvantage. So you should, sometimes people actually ask the judge to bifurcate, to separate jurisdictional and dispositional hearings. Sometimes judges do. They'll go, "Yeah, you're probably right. I should be hearing these differently because they're different. They're different things." But anyway,
Yes, they are.
they combine them, and then over the years, that just became the norm. and it spread
Mhm.
across California like you wouldn't believe. Now, s somebody in my office, I was talking about this one time, and somebody in my office said, "Oh, Mr. Davis, that doesn't make sense. Why would you not combine the jurisdictional and dispositional hearing?" And I thought for a second, and I thought, this person hasn't lived in a system where they used to be separated.
Mhm.
Now, here's the thing. When you look at the code sections that control these hearings, they're separate statutes.
Yeah, they are. That's
They're
right.
they're different laws, different evidentiary burdens, right?
Yeah, just
So
that alone should
right.
should separate it. Yeah.
So I can always tell if someone's really, really experienced because they go way back. You know, did you know that the jurisdictional and dispositional hearings are really two separate hearings that should be held different separately? Like, what are you talking about? No. What do
Yep.
you don't know Vince, you don't know what you're talking about. You don't know what you're doing. But think about
I'm
it.
sure they used to be. For my cases, luckily, they actually have been separate. That's why I was confused earlier when you were like, I mean, trial? What do you mean a trial? I mean, isn't the jurisdictional hearing kind of like a trial? And then dispositional hearing is kind of like, well, this is what I'm going to do based off of what I heard at the trial. But now what you're telling me makes
No.
complete sense.
No. No, 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 no. Dispositional hearing is only it assumes you lost the trial. If you
Hmm.
won the trial, there wouldn't be any more hearing. Case would be thrown out.
Exactly. Yeah, that makes sense, actually.
So
A
talk
lot
to
of
your
sense.
attorney. Talk to your attorney.
Hmm.
Sounds like you've got a good attorney. Talk to your attorney about, even if you lose the dispositional hearing, but if you've been doing everything that you should be doing, which I suspect you have been because you got 24 months of FR services going on, that
Oh,
by
I'm on,
definition,
yeah,
by
I'm on
definition, that
36 months.
yeah,
I'm
by
on 36
definition,
months.
that means you can't. In my mind, it's going to be hard for you to lose, but you got to have the trial. You got to cross-examine the social worker. Here's some, I have a couple of videos on YouTube on my channel about how to cross-examine a social worker. I'm going to tell you.
My attorney did actually in LA County. She's actually I don't have her anymore because the case
mm,
transferred from Lancaster to Ventura County only.
okay,
So
so
that
here you go.
yeah.
Don't write this down. Just listen because you can go back and watch the rerun that will
Oh,
be
good
on
point.
eight social media platforms forever. Okay, you
Okay.
set the worker down. The worker takes the stand. Good evening or good morning. Miss Jones.
Mhm.
Um, Tell me about your background. Blah 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 blah. Okay, Miss Jones, and go kid by kid. Miss Jones, is my client a substantial danger to little Timmy?
Mhm.
Even though the worker is recommending little Timmy not come home to you, most of them will think about that question and say, no, she's not a danger, substantial danger. She's a risk, but that's not what the law says. Risk is for jurisdictional.
Mm.
If I look at you the wrong way, I could be a risk.
Yeah.
But to say that I'm a substantial danger to you, you got to be one bad MF to be a substantial danger to a kid.
Mhm.
Now let's assume, and if she says no, you're not a substantial danger. End of
Yeah.
questioning. You win. Now, if she says
Mhm.
yes, here's the trick. Okay.
Mhm.
What I do sometimes is I take a piece of paper. Okay. This is all pre COVID, by the way, because a lot of these hearings now are online. So you can't do
Yeah.
this, or it's hard
Yeah.
to do. Take a piece of paper and a pen. Your Honor, may I approach the witness? Well, yeah, go ahead. I approach the witness. I hand her a piece of paper and a pen. Your Honor, let the record reflect that I've handed social worker Jones a piece of paper, 8.5 by 11, yellow piece of paper, you know, and a pen. Now, Miss Social Worker, what I'd like you to do, over the next few moments is to write down all of the reasons why my client is a substantial danger to little Timmy.
Ooh.
It's kind of like a test,
Mhm.
okay? Never, well, I take that back. Out of all the workers I did that over the past 30 years to, one worker actually made a list of about 12 things, okay? So
Wow.
it made my job harder. But once they
Yeah.
list like the 2 or 3 or 4 things, then you drill down on each of those things.
Yeah.
And
Absolutely.
you ask the judge to make that piece of paper an exhibit to the file, so if you ever have to appeal, the Court of Appeals will see what the social worker wrote down, okay?
Oh,
So then
yeah.
so you drill. Well, she's a drug user. Oh, you say she's a drug user? Well, she's a drug addict. Well, yeah, of course she's an addict, you know, but would you say that she's a recovering addict? Well, I don't
Mm.
know. Well, hasn't she tested clean for the past 36 months?
Mhm.
Well, I guess so. So, even though she's a recovering addict, she's
Mhm.
tested clean for 36 months. Do you still think that she's a risk? Her drug use is a risk to the child? And of course, the answer to that is yes, but she looks like a fool. If she says no, then you won that particular point that she wrote down on the piece of paper.
Yeah.
Then you go to, well, she's had domestic violence with her live-in boyfriend.
Mhm.
Okay. Now, isn't it true that she's completed 2 domestic violence courses? Well, yes. By the way, have you ever talked to any of the counselors, where she went to domestic violence? Well, no, I haven't. So it would be fair enough to say that you don't know what she learned in her domestic violence class. Well, yeah, I know what she learned. Well, how could you know that if you didn't talk to the counselor, right? So you keep going
Yeah.
along those lines. Well, has she been in another domestic violence incident since this case started or since she started her counseling? Well, no. Well, do you still think she's a risk to the child because of domestic violence? And again, it's just like the drugs. If she says yes, she looks like a fool. And if she
Mhm.
says no, you won that point. And you do that with everything that she writes down. Luckily, because of the pressure of testifying and everything, she's not going to write a list of 10 or 12 things. And if she does, you got to go through them one by one.
There wouldn't
You
be
can,
anything.
you can only do that if you have a trial where
Okay.
witnesses are called and cross examined. Now,
Mm.
remember something. Remember something. If you go to trial or a contest on anything, juris, dispo, 6-month review, 12-month review, and all the attorneys do is argue, 999 times out of 1,000, you're going to lose. And here's why. Attorney argument is not evidence.
Mhm.
So for people that are sitting in court watching their attorney argue, thinking they're doing a good job, no. Your attorney is doing a good job if you affirmatively put on a witness and examine them or cross-examine them.
Mhm.
Every case is different, before all the attorneys watching get jumped up in arms, right? Maybe the case calls for one witness or no witnesses. I don't know. Have I ever done a case with no witnesses? Yeah, I have. But for the most part, you need witnesses, you need documents. You need the social worker to get on the stand and cross-examine the worker.
That makes sense.
So, there are always problems. I recently heard where an attorney wasn't allowed to cross-examine the social worker because of the type of hearing that it was. And, um, if a
Okay.
social
Yeah.
worker if a social worker presents a report and is not allowed to be cross-examined, in my humble opinion, and I'm not always right, but in my humble opinion, you're talking about some constitutional issues, fairness, opportunity to be heard. What the social worker gets to put in a report and I don't get to cross-examine them? Like, how fair is that?
Yeah.
So on appeal, that might be an issue. You don't really want to be in the appellate business, but whatever it takes. So on your disposition hearing, make sure you talk to your attorney about a contested hearing and presenting witnesses, and for God's sake, cross-examine that social worker.
Okay, so
If
for
it, if it
dispositional hearing.
if it's appropriate, no, for the whole thing, for the whole thing.
Okay.
You know,
Okay.
did for that young child? Did you guys already have the jurisdictional hearing?
For the baby, no.
Yeah. So your jurisdictional hearing and dispositional hearing are going to be combined, right?
I hope not. I don't know yet, to be honest with you. We haven't
Yeah.
gotten to that point because I contested the detention hearing.
Oh, have you had a contested detention hearing yet?
No, that's what's coming up on the 23rd of this month.
Okay, that's a little odd because contested detention hearings are supposed to be happening like within days, unless you guys agreed otherwise.
No, they see, this has always been the case with I guess just my case. I don't know if it's because of COVID or what, but everything gets dragged on way, way longer, pretty much like to the end of the statutes that they're allowed to for everything. I mean, even just to get an adjudication hearing, or I mean, the jurisdictional hearing takes 6 months. So they just keep dragging out the time as long as possible.
In a way, that might help you. In a way, it could hurt you. It
Yeah.
just depends on what the allegations are. You know, sometimes if you have a drug case and it gets this was kind of a strategy in the old days. If you had a drug case, it didn't matter if it was true or false, because if
Mhm.
they did the hearing like 90 to 120 days out, you could get your client into drug testing. And if they were testing clean for 4 months, 3, 4 months, it'd be kind of hard for the social worker to come into court and prove by clear and convincing evidence that you're a danger, substantial danger, if you're testing
Mhm.
clean for the last 3 or 4 months. Like, okay, so she used meth 4 months ago. So what?
Mhm.
She's testing clean now.
Yeah. Yeah,
So
they're
that
they're actually trying to cast doubt on my testing because 'cause I've been testing clean for the last well, over the last year. I've been testing clean for the entire 3 years, and they're trying to say that, "Oh, she must have been faking her tests," or just little comments, and I'm like, "Well, then why don't you come and test me? Why don't you, like, do
well,
something about it if you have doubt?"
you know, if anyone says that on the witness stand or in a report,
Mhm.
talk to your attorney about objecting because it has no foundation and it's speculation.
Absolutely. This entire case is based off of speculation.
But if your attorney doesn't object to it on those bases, the judge gets to consider that. Hmm. I wonder if Kristen is faking it.
Okay.
So you got to make
Yeah,
the
see,
evidentiary objection.
okay.
You got to make
I
the
don't
objection. Speculation, no foundation. Oh,
yeah,
okay.
I
Well,
don't
I
I
can't consider that.
it it might not get to the court. This is honestly see, a lot of it's just drama. These social workers are my age, they have no children, or they're younger than me and they have no children, and it's all just I call it mean girl talk because that's what it all seems is just mean girl talk amongst themselves to the caregiver, to whoever, but a lot of it never makes it to court, or things will make it to court, say from the caregiver coming up with false allegations against me with absolutely zero evidence of it. That will go to court and they'll say for these reasons, we're taking away her overnights. We're taking away her unmonitored. We're taking away this. And for some reason, the court will read it and go, oh, okay, yeah, that makes sense. But the other 35 pages are full of my counselor saying incredible things about me, how much progress I've made in my programs, how I've enrolled in another secondary program, and the department never asked me to or even referred me. I mean, there's so many things where there's 35 pages of really good things written about me and how much I've changed my behaviors and changed this and progress with that. But then there's one little paragraph, which is the caregiver said X, Y, and Z, although they actually admit, they say, although we have no evidence and no evidence has come forward, we have decided to revoke mom's overnights and her unmonitored visitation. And the court will just go, okay. And I don't understand why. And my attorney in Ventura County he's just like, we're not going to request anything. We're not going to object to anything. We're just going through this hearing and it's just a review hearing. That's it. And
Hmm.
I don't understand that. I thought that I was supposed to be able to have that right to object really at any hearing or contest at any hearing. So I've kind of been like suppressed or held hostage like by this whole system. It's like I want to speak up and ask to address the court myself, but I'm terrified to do something wrong or come off the wrong way or seem unstable or who knows.
Right. You got to be, those are legitimate concerns. And that's why you got to
Hmm.
talk to your lawyer about these things before you do anything. Um, your case is in Lancaster?
It started in Lancaster. It transferred to Ventura County. So now it is solely in Ventura County. They combined all of my daughter's cases just in
Okay.
Ventura County.
Okay.
Yeah. Jurisdiction it's been confusing, but luckily I only have one county to deal with now. But unfortunately, um, this was the judge that did not grant me more reunification services just because they have the baby. The baby's never been taken before, um, obviously, but I haven't
Is
been
the
able to get anything on the record.
is the father of the baby involved in the case?
No, not at all. It's just me, but they keep saying that they think that the dad is a risk and that I'm still associating with him, even though I'm telling them I'm not and I haven't been. But how do I prove that I'm not associating with somebody when all they do is keep pointing the finger? That's also difficult for me.
Hold on. I'm answering Kitty's question.
Okay.
Um, you know, theoretically, you don't have to prove anything. They have to prove a case against you.
Hmm.
So hopefully you and your attorney will keep that in mind, um, at your next hearing.
I hope so too. And it has to be more than just pure speculation because I know that there's case law even that says that mere speculation is not enough. But
It's not.
I
It's
don't
not
I don't
enough.
know how they've gotten this far with it.
You know
So
why?
it's
Because a lot of times I get, this is just my own personal observations. I may be wrong, but they feel that Kirsten isn't going to do anything. Number one, Kirsten doesn't know what to do. Number two, she's not going to
mhm.
appeal. She's not going to file a writ. Her attorney's not going to do it for sure. Christian doesn't have money to go hire someone to do it. So, whatever. We'll do whatever to Kirsten and make whatever decisions that
Yep.
we make. And we
Yep.
make decisions but based upon what we think and how we feel and what we believe. And it may or may not be what the law says. It just depends.
That's
Do you
exactly
have
what
any
it's been.
do you have any questions for me before we moving towards the end of the show? Do you have any questions for me?
Um, well, I have a lot of questions, but I guess the main one would be just based on So the caregiver has essentially stalled my reunification progress, coming up with these false allegations. She's even gone as far as um, like photoshopping pictures, say of example of my car driving down a dirt road, and she's claiming that it's my daughter's dad's property, but it's not. She altered the dates and times of like when the photos were supposedly taken, and I gave the department solid, credible evidence that on this picture, I was at drug testing. There's witnesses, there's my name and the sign in time, and then the time that I left. Then the other time that she did that, because she did it multiple times, I was actually at a monitored visit with my daughters over an hour away from the alleged location where I was supposedly driving in these pictures. I gave that to the department and they looked the other way for months. And I still have not gotten my overnights reinstated. And then, same with unmonitored. They won't even give me my unmonitored visitation back. And they're just using the excuse of, oh, well, we need to have a CFT meeting. But then they've been promising me one since September. It still has not happened. I ask every day. So they're just playing games and avoiding me. And I need to file a 388 or something. I don't know what to do. How do I present that to the court? What do I do? Because time's running out fast and I'm really worried.
You're going to have to meet with your attorney, come up with a strategy and plan for this hearing. Obviously, it's a very important hearing.
Hmm. Hopefully,
That's
I'll
the
be able to convince them to do something because they're also like, well, we'll see, or we'll start working on a 388, but then
Can I make a
nothing
suggestion to you?
happens. Hmm.
I make a suggestion. And a lot of people will disagree with what I'm about to tell you. But based upon my experience, I find this to be true. You talking with social workers and trying to work with them is a bad strategy.
I'm learning that.
You know, first of all, if they were your friends, you'd have your kid back. And for the most part, they're doing a job, making money for the county, getting their paycheck. And for the most part, they're professionals. They don't give a damn about you or your kid.
Hmm.
And if they don't like you for some reason, be it true or false, you talking to them is just feeding that fire.
Very
And you should
true.
and you should probably let your attorney do all the talking for you in court and out of court. I once had an argument in chambers with a judge and a couple of attorneys. I told my client, "Don't talk to the social worker unless I'm present or on the phone." And the county counsel who represented the social worker wanted to say that that was my client not cooperating. And I think the judge was believing it until I brought up the fact that my client has a constitutional right. And I said, she
Oh,
never
yeah.
said she wasn't going to talk to the worker. She just said, well, Davis has to be present. And in a unrelated case, in suing some social workers in a county, the the attorney for the county acknowledged to me that that was a constitutional violation because they had refused to
Wow.
talk to the woman unless if I was present. They didn't want me present.
Hmm.
Okay, So you have the constitutional right to have an attorney present whenever you interact with the government. It's just your right. So now when I'm on cases, if the worker doesn't want to talk to me or I'm on a case, they'll make a county counsel show up for the interview, which they should. I don't mind. You know,
Yeah,
I don't mind that.
it'd
But what
almost be
happens,
better.
you know, what happens in a lot of these interviews is you say ABC and they write down XYZ. Or better yet, here's the one that just kills me. You say ABC and they write down CDE. A
Uh-huh.
little bit of what you said, but other stuff that you didn't say.
Exactly.
And it's so easy to take things out of context. Have you ever text with a friend or even talked to a friend and you guys are like missing each other on the communication? Like,
Of
what are you
course.
talking about? Right? Happens all the
Yeah.
time.
Yep.
Imagine it. Imagine how it could happen talking to a social worker. Things are misinterpreted all the time. You know, a lot of people would say that it's done intentionally.
It is, I think.
Some people would say that it's done by mistake. I think it's a little of both.
Yeah.
A little of both. I thought we were going to have a guest coming on tonight, but I guess my producer told her to email her. Kitty, I was hoping that you were going to come on tonight. I was going to answer your questions after Kirsten, but I guess you and Grace will have to arrange something for you to be on the show. Kirsten, before we're way past our time actually.
Okay.
Any
Thank
any
you.
any other questions you have for me?
Not off the top of my head. I'll if anything, I might call you and I mean, we'll figure it out. But thank you so
Okay,
much for taking the time to talk to me.
not a problem. You see the number down at the bottom right of the screen, 888-888-6582. So I look forward to you calling me, and we can chit chat about your case even some more.
All right. Thank you so much.
All right, thank you, and have a good evening.
You too.
All right, let me look at some of these questions. Heather says, it looks like nobody's going to get back with me, and then I got a lot of questions to ask. Nobody wants to get back with me. Somebody please get back with me, and I've been asking. Okay, Heather, if you're still on this stream and you're watching, I want you to text me tomorrow at my personal mobile number. I'm putting in the comment section, Heather. So now I'm in court tomorrow, Heather. But if you text me before 8 o'clock in the morning or after 4:30, I'll definitely try to get back to you and answer some of your questions. Okay? All right, I placed that number in the sections. And then Kitty, I guess you've talked to Grace, or you'll talk to Grace about your questions that you have. Here's Jack. Jack says, you have to call in. Vince is a lawyer. I'm just to be honest. You'll be lucky. His time costs money. They are very busy. Just being fair. I respect him. Call into his office. Yeah, if you have questions, you guys, call me in the office. We put this telephone number, toll-free telephone number, up on the screen for a reason. Also, please like and subscribe to the page you're looking at this show on. Check out this report, bottom left-hand corner, freecpsreport.com. Check that free report out. Check this report out, suecps.info, another website with some great free information. So please take a look at that. Okay. And, I should have asked our guest. We are looking for hosts. We're trying to make these shows about CPS, you know, 12 hours a day, 24 hours a day, 7 days a week, just information about CPS in your case. It's affecting, tens of thousands, if not hundreds of thousands of people across the country. So give us a call at 888-888-6582. All right, I want to thank everyone for watching this evening. Please check us out tomorrow night, 7 p.m. The Secret, How to Fight CPS and Win.